Three types of business bankruptcy you gotta know. According to the U.S. Small Business Administration, more than 70% of new small businesses don't survive and are faced with the decision concerning whether they should file for some form of business bankruptcy. Between 2005 and 2017, only about 1/5 of new small businesses survived more than 1 year. About half of those businesses continued on for up to 5 years, while only about 1/3 made it to 10 years. Find out what Chapter 7, Chapter 11, and Chapter 13 stand for, respectively, and which type of business each applies to. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. And if you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about three types of business bankruptcy you gotta know. But before we even get into the nitty-gritty here, remember that there are three types, and the type you file for depends on the company structure. Sole proprietorships are legal extensions of the owner. The owner is responsible for all assets and liabilities of the firm. It is most common for a sole proprietorship to take bankruptcy by filing for Chapter 13, which is a reorganization bankruptcy. Corporations and partnerships are legal business entities, so they are separate from their owners. Let's just talk about the type of bankruptcy that corporations file. Chapter 11, that's the first one. Chapter 11, business reorganization. Chapter 11 may be a better choice for businesses that may have a realistic chance to turn things around. So Chapter 11 business bankruptcy is usually used for partnerships and corporations, right? Only two types, partnerships or corporations. By corporations, I mean S corporations or C corporations. It is also used by sole proprietorships whose income levels are too high to qualify for Chapter 13 bankruptcy. Chapter 11 is a plan whereby a company reorganizes and continues in business under a court-approved trustee. The company files a detailed plan of reorganization outlining how it will deal with its creditors. The company can terminate contracts and leases, recover assets, and repay a portion of its debt while discharging others to return to profitability. It presents the plan to its creditors, who will vote on the plan. If the court finds the plan is fair and equitable, it will approve the plan. Reorganization plans provide for payments to creditors over some time. So Chapter 11 bankruptcies are exceedingly complex and not all succeed. It usually takes over a year to confirm a plan. Now, there are a few elements you need to keep in mind when it comes to Chapter 11 business reorganization. This is how it's called, Chapter 11 bankruptcy. We have something called debtor in possession. The goal in a Chapter 11 situation is to restructure the debt so the company, small or large, doesn't matter, may stay in business. A business debtor may be a corporation, partnership, or sole proprietorship. The debtor files an order of relief but remains in possession of the property while developing a plan to increase revenue to pay off debts. If creditors suspect fraud, they may request a trustee to handle financial arrangement until an agreed upon plan is in place. A debtor in possession also is allowed to borrow funds and may apply to receive unsecured credit without court permission. Let's talk about the timetable. So after submitting an order of relief, the debtor has 120 days, that's 4 months, to create and file a reorganization plan. For small businesses and businesses with debts of less than $2 million, the timetable may be fast-tracked to 100 days. All creditors must approve the plan with 180 days of the order relief, or 160 days if fast-tracked. If the debtor does not submit a plan in time, or if any of the creditors fail to consent to it, the creditors themselves may submit a plan. Sometimes the court will extend the debtor's exclusivity period for up to 18 months. So unless an interested party or the court calls everyone to act in a timely manner, the case can go on for years, and nobody wants that. Let's now talk about mandatory provisions in a Chapter 11 bankruptcy. Your Chapter 11 plan must contain specific mandatory provisions. First, all claims must have a classification. Each secured claim can be classified separately, and you may use general classification for unsecured claims, while employees may be a third class. Now, you can classify claims together if the claim or interest is substantially similar to the other claims or interest of the same class. So the plan also must contain a method of treatment for each claim in a class. Additionally, your plan requires a method of implementation, including a provision for elected directors with the same interest as the creditors. Let's talk about impairment classes. You must include treatments and explanations for all impaired classes in your plan. What is an impaired class? An impaired class is a group of similar claims that will not be paid in full as of the effective date of a confirmed Chapter 11. Impairment is important because unimpaired classes assume the acceptance of the creditors, and solicitation of their acceptance is not required by law. Now let's talk about permissible provisions in a Chapter 11 bankruptcy plan. Permissible provisions are those not required by law but which help provide for the settlement of all claims. These provisions can impair any loss, including unfulfilled lease agreements, reject or assign uncompleted contracts, provide for the liquidation of any of all assets, or provide for any other relevant measures in the bankruptcy code. Permissible provisions also provide for modifying secured or unsecured creditors' rights to full payments, partial payments, or the surrender of the secured party. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. I hope you are having a good time here with this conversation. This is a conversation that is deep. We need to go deep. Bankruptcy is serious business. And if you love this kind of content, you love the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so you can receive immediate updates whenever we drop a new show. And we do this every single day, not only about law or finance, but we cover a whole host of topics. You can also comment below if you have a question or you have some kind of feedback you want to give on the show, or you have some kind of general experience you want to share. Feel free to comment below. Also, share this content and like it. Let's talk about Chapter 7, Liquidation. Remember, Chapter 11 is usually called Business Reorganization. Chapter 7, Bankruptcy, is usually called Liquidation. So Chapter 7, Business Bankruptcy, may be the best choice when the business has no viable future, right? Liquidation comes from there. If the business has no viable future, go with Chapter 7. It usually referred to as liquidation. So Chapter 7 is typically used when the debt of the business are so overwhelming that restructuring them is not feasible. Chapter 7 bankruptcy can be used for sole proprietorships, partnerships, or corporations. Chapter 7 is also appropriate when the business does not have any substantial assets. If a business is a sole proprietorship and an extension of an owner's skills, it usually does not pay to reorganize it, and Chapter 7 becomes appropriate. Before a Chapter 7 bankruptcy is approved by the court, the applicant is subject to a means test, something called means test. If their income is over a certain level, their application will not be approved. If a Chapter 7 bankruptcy is approved, the business is automatically dissolved. In Chapter 7 bankruptcy, the court will appoint a trustee, and this trustee will take possession of the assets of the business and distribute them among the creditors. After the assets are distributed and the trustee is paid, a sole proprietor receives a discharge at the end of the case. A discharge means that the owner of the business is released from any obligation for the debts. Partnerships and corporations do not receive a discharge. Now, let's move. That was for Chapter 7. Let's move on to Chapter 13. This is called Adjustment of Debts for Individuals with Regular Income. Chapter 13 bankruptcy is a reorganization bankruptcy typically reserved for individuals. It can be used for sole proprietorship since since sole proprietorships, as I said before, they are indistinguishable from their owners. Chapter 13 is used for small businesses when a reorganization is the goal instead of liquidation. You file a repayment plan with the bankruptcy court detailing how you are going to repay your debts. So Chapter 13 and Chapter 7 bankruptcies are very different for businesses. So Chapter 13 allows the proprietorship to stay in business and repay its debts, and Chapter 7 does not. The amount you must repay depends on how much you earn, how much you owe, and how much property you own. If your personal assets are involved with your business assets, as they are if you own a sole proprietorship, you can avoid problems such as losing your house if you file Chapter 13 instead of Chapter 7. Right? Okay, I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. And I just want to wrap up today's conversation, but I want to talk about the 2019 Small Business Reorganization Act. This is an important act that has had a great impact on the kind of bankruptcy that small businesses are allowed to file in the next few years. In August 2019, the Small Business Reorganization Act of 2019 was passed by the U.S. Congress and signed into law by the President. It enacted a new subchapter 5 of Chapter 11. So the act is in effect as of February 20th, 2020. This subchapter of Chapter 11 seems to favor the side of the applicant for business bankruptcy. It only applies if the applicant wants it to apply. This is very important. So for example, subchapter 5 does not require that a committee of creditors is appointed or that directors or that creditors have to approve a court plan. Sole proprietorships or incorporated entities should consult with a good business bankruptcy attorney before deciding on which type of bankruptcy you will file or whether you need to file for bankruptcy at all. There may be other options that can be explored. So we have here on the screen, and we also have the link to the Congress, to the bill. So it's www.congress.gov/bill/116 Congress/House Bill/3311/text, and we have a screenshot here that we have taken. You can see it here. So it's called HR 3311, and this sort of gives you a great idea of what the law is. If you want to read more about it, you can go to that link and see it. It is important because of the introduction of, like I said, the subchapter 5 in the Chapter 11 bankruptcy proceedings. All right, so this is it, folks. This is today's conversation. I hope you enjoyed it, added value to your life or your business operations. And kind of quickly recap today's conversation here. I spoke about Chapter 11, business reorganization, and I spoke about a few things that are important in Chapter 11, such as debtor in possession, timetable, mandatory provisions, impairment classes, permissible provisions. And then I have Chapter 7, that's called liquidation. Chapter 13, adjustment of debts for individuals with regular income. And I've finalized everything with the 2019 Small Business Reorganization Act that has a huge impact on the bankruptcy industry. All right, thanks, folks. I will see you next time. And until then, stay marvelous.